Rocket Launchpad. And now, here's Johnny.
Hey, it's Johnny Rocket here at the Johnny Rocket Launchpad, launching ideas in your direction. The Northwest's only rock and roll libertarian radio show. I'm here with my co-host, Mr. Kurt Nelson.
That is correct, sir.
The voice of reason, the beautiful Heather Nixon.
Right again.
And we are speaking with Pacific Legal Foundation Principal Attorney Timothy Sandefur. Woo! Bam!
Thank you again for being with us today, Timothy.
Thanks for having me on.
This is really awesome. Really awesome.
I've been watching a lot of your speeches, your videos, and things along those lines, and you were talking about how judges have used their opinions to kind of mold their own vision. Can you expand on that?
Well, I mean, this is something judges have always done ever since the law has existed, that they issue a decision and they write out an opinion that explains their views about the law and takes a position. And so inevitably, people who disagree with them are just typically accuse them of not just of reasoning badly, but of going beyond what they're supposed to do. And so you hear a lot of people today criticize judges for judicial activism. Mm-hmm. But typically judicial activism is just something that means I disagree with what the judge decided. Mm-hmm. It doesn't usually really mean much more than that, because judges are supposed to take an active role in enforcing what the Constitution and what the laws say. And if the laws are unconstitutional, the judge is supposed to take an active role in striking down the law.
Right.
And unfortunately, today, there's this anti-judicial activism thing, which you typically hear from conservatives.
Sure.
What it ends up being is that they're basically arguing that whatever the majority votes for should just be the law. And that problem with that is, what about when the majority violates individual rights or does something that's unconstitutional? We don't live in a majority will society. It's not a winner take all country. We live under a constitution that exists to protect us from the majority. The reason we have a constitution is to protect me against the majority of people out there, because let's face it, I mean, I went to junior high school. I was an unpopular kid. I know what politics is like, you know. Politics majority is always everybody except you, you know.
Right.
The role of the courts is to shield unpopular minorities and to make sure that the government operates according to the law.
That's just why we're a republic, not a democracy.
Yeah, that's right. We're a system of laws, not of men, is another way people put that. We're not supposed to be a system where your political ideas basically dictate how much freedom you have. You know, it should be, ideally, I get to vote for my candidate, you get to vote for your candidate. Maybe my candidate loses, and then I get to go home and I'm still safe in my house with my belongings and with my freedom of speech and with my freedom of religion and so forth. In other societies, that hasn't been the case. In other societies, if you vote for the wrong guy, the next morning you wake up and you don't have a house, or you don't have your freedom, or you don't have freedom of speech. You know, you get thrown in jail or something. So the reason we have a constitution is to provide a legal barrier, a system of law that shields us against politics. And what I think is a real shame is people are trying to water that down and make the courts do whatever the majority wants it to do, and that's very dangerous.
I have a quick question for you. If we can go back for a second, we were talking about judges. I've been to court a handful of times for whatever miscellaneous small reasons. It's always dawned on me that judges that I've seen in courtrooms, state judges, and anybody who ever loses in court always thinks the judge is an asshole. It's always been my opinion that from what I've seen, there's a lot of red tape that goes back and forth in the courtroom. And I'm talking about misdemeanor criminal law or traffic court or whatever, small stuff. I've always thought the judges that I've seen seem to be fairly right on, even mature in a legal sense. Is that been your experience, or do you run into a lot of just real dickhead judges? Sorry.
No. Well, first of all, as a practicing lawyer, I would never say that.
Yeah, I guess you can't. I guess
that guy's a dick.
But no, honestly, though, I have run into very few judges that I think are in any way unqualified or anything like that. I think most judges take their positions very seriously, and even if I disagree with them, that's what I love about the law, as opposed to politics. In politics, it's just whatever's popular. Whereas in the law, even if they decide wrongly, they at least give you a reason. They'll at least give you a written opinion that says, here's why I decided the way I did. And you can point to it and say, this is why I think the judge was wrong. You can't do that in politics. It's so mushy and unprincipled in politics that I have little tolerance for that.
Yeah. Absolutely. And like we had a guest a couple of weeks back now. We were talking about judicial review. Was it an overstep of the judicial branch, or was it an implied duty?
Oh, it's I think very obviously an applied part of the Constitution. The Constitution says, in one part, it says, this Constitution and laws made in pursuance to it are the supreme law of the land. Well, if the Constitution and the laws made in pursuance of it are the law of the land, then that raises a question. What about laws that are not made in pursuance of the Constitution? What about laws that are contrary to the Constitution? Are those the supreme law of the land?
Right.
The answer is obviously no. The Constitution only says that it and the laws that are consistent with it are the supreme law of the land. Well, that means that a judge who he's asked to decide a case, and he has to look at that law and decide whether that law is consistent with the Constitution, because if it's not the supreme law of the land. So that by that reasoning, judicial review, the court's authority to determine whether a law is constitutional, is just inherent in the role of judges, and it's right there in the Constitution.
We were talking about progressives. What is a progressive by your definition?
Well, that is a hard question to answer, because progressivism, the historical phenomenon, it was a political movement that began in the late 19th century and is basically still continues today.
Okay.
That was a very widespread phenomenon. You found there were progressive Republicans and progressive Democrats, and they often disagreed with each other. And so it's kind of hard to really give an exact definition of progressivism. Okay. I say that progressivism has four primary ideas. The first one is rights are just permissions that the government gives to us for the government's own purposes. That's a fundamental position of progressivism. Progressives don't think that rights belong to you because you're a human being. They think that the rights are given to you by the government for the government's purposes. So freedom of speech, for example, is not, you don't have freedom of speech because you own yourself and you have the right to speak your mind.
Right.
Progressive thinks that you have the freedom of speech because it's good for democracy to allow people to debate. So we give people freedom of speech for political purposes. The second progressive idea is that government exists to make an ideal society. Libertarians don't think so. Libertarians think that government exists to secure individual rights.
Right. Absolutely.
And that's it. And it doesn't exist to build shopping malls or improve the local community or ensure that you eat healthy.
Or improve the aesthetics of your neighborhood.
Or buy property for Costco.
That's right. Yeah. And the progressives thought, no, government exists to make society flourish. And so they had all sorts of great ideas like eugenics and segregation and prohibition of alcohol. These are, progressives tried to outlaw divorce. These ideas were all to improve society through the active use of the state.
Right.
The third progressive idea is that the Constitution is a living document that changes its meaning depending on the needs of society. So it may have meant one thing one day, but it can mean the exact opposite of it the next day, depending on what society needs.
Right.
And then the fourth progressive idea is that courts really shouldn't be involved. They really should not intervene in the political process, basically ever. And when they do, it should only be to allow the political debate to continue, so that courts really just serve the interest. They're like a referee for the legislature. They don't exist to protect individual rights because, go back to step one, rights are just given to us by the government. Right. So progressivism, I think progressivism is very well summed up in a sentence by a Supreme Court justice named Louis Brandeis, who started out as he was a lawyer who in favor of progressivist causes, who then became famous and got appointed to the Supreme Court. And he said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. Well, if it can be remolded, it's to meet society's needs, it's not a right.
It's kind of scary.
Yeah.
It's just a privilege that's given to you by the government. So that's really what progressivism is about.
Wow, that's great. Most people think progressivism is associated most of the time with the left, but the Republicans and the right do it also.
Sure.
That's right. And Theodore Roosevelt, for example, was a progressive Republican. And today, most leading Republican political candidates, people running for office and so forth, most of them are progressives, whether they know it or not. They believe that the government should be in charge of our morality, should dictate to us, for example, what drugs to take.
Right.
the war on drugs is really a fundamentally progressive idea. It was created by Richard Nixon, a progressive Republican, who believed in actively using the state to ensure that people did things that were good for them and didn't do things that were bad for them. And the way he did it was getting a federal law passed, the Controlled Substances Act, that exploited the Commerce Clause of the Constitution to allow Congress to control even what you do in the privacy of your own home. A very progressive idea. And like I said, prohibition of alcohol was a progressive cause. The Constitution was amended during the progressive era to allow the government to stop you from drinking.
Yeah, I'm not cool with that one.
Yeah. Well, you really cannot make an argument for prohibiting marijuana that is not just as applicable to prohibiting alcohol. And yet, I mean, alcohol is the most dangerous drug that we have in our society. And yet it's not only legal, but considered perfectly acceptable to drink a glass of wine at dinner or toast the new year with champagne.
Absolutely.
And people are perfectly fine with that because they know that they can drink responsibly.
Right.
And yet when it comes to marijuana, it's, reefer madness and it's going to be a scourge on society. And the government should track you down in the privacy of your own home, shoot your dogs, drag you away in the middle of the night, and imprison you because you smoke a plant that the government disapproves of.
No, I'm with you on that, man.
According to Governor Christie and many others, it's a gateway drug. So if we try some reefer, next thing you know, we're going to be shooting up heroin and killing babies.
Timothy, have you taken any marijuana law cases?
No, we don't do those kinds of cases. There are many organizations out there that are concerned with that area of the law. We are kind of tangentially interested in them because I mentioned the Commerce Clause thing. The Controlled Substances Act says that the federal government can prohibit the selling or even the growing of marijuana and other kinds of drugs because the federal government has power to regulate commerce among the several states. The problem is that has been so exploited to allow Congress to dictate all sorts of things, including, I mentioned the Endangered Species Act. That was another Nixon-era law that was passed under the Commerce Clause.
Yep.
That is basically a form of federal zoning. It's a system that says if you want to build something on your property, you need to get a federal permit if there's a Delhi Sands flower-loving fly on your property. and that's exactly the same logic as the Controlled Substances Act. It's the idea that government exists to make society nice and that the federal Constitution can be read as broadly as necessary to allow Congress to dictate to you how to live your life.
Judges use rational basis test. This is what you were talking about. What is a rational basis test?
The rational basis test is the legal test that judges use in trying to decide whether a law is unconstitutional in certain kinds of cases. So if you go to court and you say a law is unconstitutional, the judge decides whether to apply this rational basis test or another kind of test called strict scrutiny. And you decide whether to apply the test based on what kind of right is being violated. So if your freedom of speech is violated, the court uses the strict scrutiny test. And what that means is that the law has to be really carefully designed to do a very important thing and do it well. If it doesn't meet that high standard, then it's unconstitutional. So those kinds of laws are almost always unconstitutional. That's why the government can hardly ever deprive you of your freedom of speech or religion.
Okay.
On the other hand, if it's another kind of right, a right that courts don't care about, like the right to earn a living, then the court applies this rational basis test. And that test says basically that the court closes its eyes and tries to imagine if it's possible that anybody could have ever thought the law would be a good one.
Right. Totally.
And that's basically the test that the court uses. And then
it's kind of magic.
Yes, right. And the law is presumed to be constitutional. And you, as the plaintiff, you're required to prove that it's unconstitutional. Now, think about that for a second, because in the criminal law context, the government can't throw you in jail unless it proves that you committed the crime. You're presumed innocent until you're proven guilty. Right. But when it comes to your economic freedom, the government can deprive you of your economic freedom unless you prove that you ought to be free.
Okay.
Which, of course, you can't. How do you do that? You can't prove a negative. You can't disprove the constitutionality of a law. It's impossible to prove a negative. So it makes it almost impossible to win those kinds of cases, which is why I said at the beginning, it's such an uphill battle to win cases on behalf of business owners.
Is most laws fraud? I mean, really, if you think about it, the whole point of government was pretty much there to protect our life, liberty, and property and or pursuit of happiness. You want to go Locke or Jefferson, which one? But I mean, really, to me, it's like there's just so many bullshit laws out there that just are irrelevant.
And it's not really laws that are as much a problem as it is regulations.
Okay.
What happens is the laws very often get passed that are very simple laws, but what they do is they're written in very broad and vague terms, and then they turn and they hand the power over to an administrative agency, a group of bureaucrats, and they get to decide what is legal and what they'll investigate, what they'll punish, those sorts of things. And those are far more dangerous because the bureaucrats, you don't vote for bureaucrats. You can't vote the bums out if they do their thing. So, for example, the Endangered Species Act. The Endangered Species Act is basically a blank check to the Environmental Protection Agency and other administrative bureaucrats to decide how to regulate the use of land in the country. Or the Clean Water Act. The Clean Water Act makes it a crime to discharge a pollutant from a point source into a water of the United States. Okay, so what is a water of the United States?
Right.
It's anything.
It's
whatever
anything.
the government
It could be
says.
rainwater. It could be a lake.
The bureaucrats get to decide what is a water of the United States.
Yeah, that's crazy.
They get to decide what a pollutant is, that sort of thing. So that's even much more of a danger than actual laws, is the thousands and thousands of regulations that you don't even know that they exist.
Sure.
They're out there waiting to trip you up.
Right. I know specifically of here in Washington, in the city of Auburn, they sold a piece of property that was to be developed as a horse track for horse racing, to build a track. And they're the one that sold the property. The permits were in place, and then they went to do the work on the property. And the bulldozers, the tracks, created divots in the soil and collected rainwater. And then the city of Auburn declared it a wetland, and this person could no longer develop the land.
That's right. And this is a controversy that's going on in Congress right now because they're trying to decide what qualifies as a water of the United States. And this is a current debate because the federal government has proposed a regulation that would allow it control over virtually any wet spot in the country. It's really a terrible idea, and we're trying to fight that right now.
What are some hilarious arguments against compensating people for government taking?
Oh, actually, I'm glad you asked that question today, because just today the Supreme Court heard a case on just that question. There's a case that involves a law. Now, whenever I talk about this, I have to say up front, I am not making this up. You're going to think I'm making this up because it's so stupid.
Okay,
nice.
We want to hear
But
it.
in the 1930s, the federal government created a system where the government confiscates up to half of the entire raisin crop of the United States.
Wow.
Remember, almost half of all raisins in the world are grown in the Central Valley of California, and half of those are condemned by the federal government every year under a program that exists in order to raise prices for raisins. So this law exists to make raisins more expensive for mothers to give to their children. And when the government takes these raisins, it then gives them, sells them under a government-owned brand name to public schools, or it sells them in foreign countries at prices that undercut the farmers in those countries in order to keep them in poverty.
Right.
And then whatever money is left over from that, it will then give back to the raisin growers who had their raisins stolen from them. So the raisin growers sued, arguing that this is a taking of their property and they're entitled to compensation for any taking of their property. There's their raisins. The government should pay them for them.
Right.
Well, the court, the lower court, the trial court said, no, it's not a taking of your raisins. It's really just a tax that the government is imposing for the privilege of selling your raisins in interstate commerce. Now,
wow,
how many things are wrong with that statement? First of
like
all,
all of them?
The idea that it's a tax in the first place, but secondly, that they can tax you for the privilege of selling your raisins. What do you mean privilege? you have the right to sell your raisins because they're your raisins. There's a reason why we use the phrase "fruits of your labor," right? You have the right
Nice.
to sell the product of your labor, and and then this idea that it's a privilege to sell your raisins in interstate commerce. As I just said, the courts have expanded the Commerce Clause so broadly that you couldn't sell raisins on the sidewalk to pedestrians without following afoul of the laws about selling in interstate commerce.
Right.
Well, this case was heard today in the U.S. Supreme Court, and the federal government even tried arguing that, well, the raisin growers actually benefit from this law because it keeps the prices up. Well, okay, on that theory, then, the federal government could force Apple to give up every third iPhone to the government for its own use, and the government doesn't have to compensate you because, after all, fewer iPhones means that each iPhone costs more.
Right.
And therefore, you really benefit from the government's These are the kinds of arguments that the Obama administration particularly has been putting forward lately, and it's no wonder that they keep losing case after case after case.
Right.
So this is a recent thing still.
Well, this law was passed in 1937, but yes, it remains on the books to this day. Really, and it's astonishing. Justice Kagan recently called it the most outdated law on the books, and Justice Scalia, of course, said that it was absurd and that it was like the Russian control over the Soviet economy in the 1930s, which in fact it is exactly like that.
Totally.
It's government planning of the economy in order to accomplish what bureaucrats think society ought to look like.
That is crazy. What is public accommodation laws, and does it take away rights away from the property owner?
Well, public accommodation laws typically exist in the civil rights context, and the idea behind them is that right after slavery was ended, Southern states passed a lot of laws or just had social practices that of segregation, of not allowing the free blacks to go to movie theaters or stay at hotels and things.
Sure.
And so civil rights laws were passed that prohibited the hotels and movie theaters from excluding people on the basis of race. And they do infringe on private property rights, but in the context of civil rights laws, we consider that to be justified because of the history of slavery.
Okay.
Now, the problem with that is that that theory has been expanded and expanded and expanded to pretty ridiculous degrees. Probably the most famous of these is in the 1960s. There was a small restaurant that violated the Civil Rights Act, and it was brought up on charges, and they said, well, we're not engaged in interstate commerce, so the federal government has no authority to tell us whether we can or cannot discriminate against people.
Okay.
And the court said, no, you are engaged in interstate commerce because you get a portion of your meat products from a farm that's located out of state.
Right.
And your business is insured by a company that's located in another state. Well,
pretty much everyone is.
This is the theory of the little old lady that swallowed the fly.
Well, it's the butterfly effect, in a
That's
sense.
right.
Oh, it's crazy. I think it's absolutely nuts. Anyways, this is Johnny Rocket here at the Johnny Rocket Launchpad, launching ideas in your direction in Northwest only rock and roll libertarian radio show. I'm here with my co-host, Mr. Curtin Nelson.
Yes, sir.
My beautiful Heather Nixon.
That's right. I belong to you.
I belong to you, baby. And we're here with Timothy Sandefur from Pacific Legal Foundation and scholar at the Cato Institute. Stick around. We got some more questions for him. We'll be right back.